Sure, we're going to look at elements of a crime, and the learning target is I can outline the rights of the accused and integrate due process concepts from Chapter 16. Elements of a crime. A crime is the intentional commission of an act that violates the law. To qualify as a crime, an act must consist of two basic elements. It must be wrongful and it must be carried out with intent. To be wrongful, an act must do harm to others or to society. A crime must always be defined through a law that specifies a particular act as illegal. People commit many wrongful acts every day in our society, but not all these acts are crimes. For a person's bad behavior to qualify as a crime, it must have been described and prohibited by law before the act was committed. Furthermore, a behavior can be labeled criminal only if an illegal act was committed with intent. In other words, the act of wrongdoing must be accompanied by the conscious intention to carry out the act. Such behavior is considered criminal even if the suspect is ignorant of the law. So just remember that it must be wrongful and carried out with intent. There are two types of crimes, and you probably have heard of these before. There's actually more, but these are two of the more typical ones. You have misdemeanor, and that's just looking at a criminal offense that is generally less than a serious felony, and is also usually you serve less than a year, so it'd be like in a jail cell instead of prison. Prison's for longer than a year, and jail is for shorter sentences. And a felony can result in extended prison time. And here are some examples of felonies on this page here. You can see murder and theft and robbery, threats to public peace, treason, drug crimes, white-collar crimes. So all those, the more the worse the crime, the more likely it is a felony. If it's like shoplifting or something, which maybe you know a friend or something that had done that at one point, that would be a misdemeanor, and that wouldn't be such a big deal as long as it's not over a certain amount. Once it goes over a certain amount, then it can be considered a felony as well. Looking at the juvenile process, due process rights are just a little bit different for kids under 18. We try to separate the adults and the juveniles, so we try to give them maybe a little bit different rights. And the juvenile courts created these reforms to take the circumstances of young offenders into account when handing down sentences. And so juveniles have the right to be notified of the charges, right to an attorney, right to confront witnesses, right to remain silent. And the one thing that's maybe a little bit different is juries are not mandatory in juvenile cases. And I'm going to go through the 7 stages of the criminal justice process here. And so it starts with a crime. That's actually stage number 1 is the crime. And then ending with the corrections. And the second step is the investigation. And during this step, the police might obtain a search warrant. And we've talked quite a bit about search and seizure. So law enforcement officials must present that evidence to a judge in order to obtain a search warrant and to look around your house or to possibly look in your garage or something like that if they are looking for something. And that search warrant would have to list the items that they're looking for. And we've talked a little bit about this, exceptions to a search warrant. Again, if it's a stop and frisk, sobriety checkpoints, airport searches, student searches, if you consent to it, like the little cartoon here says, then that would be an exception to a search warrant. You wouldn't need to get one for that. And then also during a lawful arrest, if something's in plain view, if a cop is chasing you into your house, and then he can go into your house as well without a search warrant, and auto searches. So those are all searches that can be done without a warrant. Step 3 is the actual arrest. And we've talked quite a bit about Miranda v. Arizona, but it helped ensure that police officers observe due process when taking suspects into custody. This decision requires officers to inform suspects of their rights as they are being arrested. And then they can be booked or processed, and during that time, they are asked to give their name, date of birth, and other personal information. They are informed of the charges against them. Though these charges will later be stated more formally in a courtroom, they are fingerprinted, photographed, and searched. In some cases, suspects are required to stand in a police lineup to be viewed by witnesses. During the booking, an officer confiscates a suspect's personal property. The officer makes a list of everything taken and has the suspect sign the list. The suspect has a right to make a phone call during booking. Most suspects call family members, friends, or a lawyer. In some cases, a lawyer may be able to get the charges dropped. Otherwise, the suspect has to remain in jail, awaiting the next stage in the criminal justice process. Hopefully, none of that happens to you, but I guess you know that at least you get your phone call, so make sure you ask for it. Number 4 is the pretrial activity, and the Sixth Amendment requires that the criminal prosecutions move quickly. Within 48 hours of the arrest, suspects must have the opportunity to appear in court. At this first pretrial appearance, they are reminded of their rights and of the charges against them. They also are told if they cannot afford an attorney, they'll get one appointed. Suspect's initial appearance in court also offers the possibility of release from jail. A judge will decide whether a defendant should be released from custody and under what conditions. And of course, that's called bail if they're able to do that. So bail is just the money that a defendant hands over to the court as a guarantee that he or she will return for the trial. If they are considered a flight risk, they might not be allowed to have bail, or they might set it quite a bit higher. During the next pretrial step in most felony cases is the preliminary hearing. The purpose of this hearing is to determine whether there is enough evidence to take the case to trial. The prosecutor must prove that there is probable cause that a crime was committed and that the suspect had committed it. And then sometimes grand juries get involved, and a grand jury is a type of jury that weighs evidence and determines whether a trial is warranted. A grand jury consists of 16 to 23 jurors, and they look at a number of cases during a time period, and they just look at, did a crime take place, and did this defendant commit it? If they believe the answer to both parts of the question is yes, they will return an indictment or a formal accusation against the suspect. And then after the grand jury has done that, the person has a chance to enter a plea, and they might say not guilty, or they might enter a plea of guilty. They also might set a plea bargain, and you've probably heard of this before, but that's just an agreement in which the defendant pleads guilty in exchange for a lighter sentence. And so that can be a benefit, because maybe a jury, they might be worried that a jury would convict them and they'd have to serve more time. So usually it ends up being a better deal for them. Plus, then one of the pros is that it reduces the number of trials, reduces the amount of time and the money that it takes for those proceedings to happen. And then if they don't enter a plea bargain, then of course you would actually have the trial. And so you have a right to a fair and impartial jury. You have the right to adequate defense, and the burden of proof rests with the prosecution. Again, the jury would have to find you guilty beyond a reasonable doubt. So the prosecution would have to be the ones to share the evidence with the jury to convince them. 6, if you are found guilty, and hopefully we're not talking about you, but if you were, it's up to the judge's responsibility to assign the sentence. Jurors can make some recommendations, but ultimately it's the judge's responsibility. An option besides prison may be restitution, and that means the defendant must pay back or make up for whatever losses the victim has sustained. And then the correction system itself, we look at the prisons and parole and pardons, and prisons provide the basic standard of living, and we have inmates that come in and speak once in a while, and they kind of share kind of what that looks like. And the parole process, it varies from state to state. In some states, prisoners must apply for parole by submitting a request to the parole board. In other words, the parole board automatically considers parole when prisoners have served a certain amount of time of their sentence, and the prisoner may even ask to appear at a parole hearing. At the hearing, the parole board hears testimony and examines evidence to determine whether the parole should be granted. And then many released prisoners find their return to society is not smooth, obviously. For one thing, the released prisoner now has a criminal record, which can make it difficult to find a job or a place to live. In some cases, former prisoners may decide to apply for a pardon, and so pardons restore all rights that were lost by the offenders when they were convicted if they find out that they actually hadn't committed that crime. Pardons can be granted only by the president in the case of a federal crime or by governors in the case of state crimes. Pardons are rarely granted, however. When they are, they restore all the rights that were lost by offenders. And that is the 7 steps in the criminal justice system.